This is Agriculture Today, and I'm Shelby Varner with the K-State Radio Network. Starting off the show is K-State and Washburn law professor Roger McEowen as he chats about a recent case in Kansas that involves joint tenancy and if he thinks the court went too far. K-State weed scientist Jeremie Kouame keeps the show rolling as he discusses pre-plant herbicide options for grain sorghum and what other tools might be available for weed control. Part of the Beef Cattle Institute's Cattle Chat podcast with Brad White, Bob Larson, and Phillip Lancaster ends the show as they share their thoughts on the financials for cow size and herd size. That and more is coming up ahead on Agriculture Today. You're tuned in to Agriculture Today, and we start our Wednesday show talking about a recent case that involves a 40-acre farm in Jefferson County with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Well, thanks for having me, Shelby.
Roger, beginning talking about this case that involves a 40-acre Jefferson County farm, and what is this case and why is it so important for agriculture?
Well, it's a big case because normally when we own property in joint tenancy with rights of survivorship, when a joint tenant dies, then the surviving joint tenant or tenants then automatically become the owners of that property. And it's a very, very common form of ownership for farmers and ranchers simply because it's simple. And also it's gained in popularity because the federal estate tax exemption is so high and there's no tax imposed at death in Kansas, that it's a very, very simple form of ownership that then doesn't have tax consequences compared to other forms of ownership at death, with those exemption levels being high or at the state level non-existent. So it's very popular, very easy. A lot of people do it, and they may think that they're very secure in that ownership interest once a joint tenant dies. But now we've got a surprise in Kansas.
What joint tenancy was happening on this property?
Yeah, what we had here was a farm that was originally belonged to a person who deeded the property in 2011 to herself and her son and her partner as joint tenants with rights of survivorship. And then when she died in 2018, then her son and partner remained joint tenants. And that meant that when one died, the survivor would automatically own the property outright, as I explained just a moment ago. But shortly before the one joint tenant died in 2021, so this is after Mama had died, and now you've got the two joint tenants that own it. Now one of those died in 2021. He signed an installment contract for deed with two buyers, with a couple that were going to buy the property. And this was to sell the entire property. And the contract acknowledged the joint tenancy interest, but asserted that he had abandoned the farm and had vacated the property and gave the purported buyers the key and the garage door openers, and reportedly stated that he wanted to move to Colorado and be done with the property. Now, meanwhile, his co-joint tenant has no idea this is going on. So after he dies, the co-joint tenant learns of this. Of course, he knows that his co-owner has died, and he sees that, well, he abandoned the property. He had a contract that he was executing with these people. Now, it didn't get finalized before he died. And he's arguing, wait a minute, I'm the exclusive owner of this property. Buyers don't own anything. The joint tenancy was not severed, and I own it by the survivorship feature.
So did he get the property?
Well, the trial court disagreed with him, and that ruling was upheld by the Kansas Court of Appeals, kind of strangely so. But the appellate court said that the co-owner had severed the joint tenancy before his death because, and this is the key point, his conduct demonstrated an intent to terminate the survivorship arrangement. Now, what's key about this is that deceased co-tenant never actually conveyed title before he died. There was no deed that transferred his interest. There was no partition action. And he remained a record joint tenant the entire time. But nevertheless, the court concluded that his execution of the contract for deed, the recording of an affidavit of equitable interest, surrender of possession, transfer of keys, statements about leaving the property, all of that put together constituted sufficient, as the court said, intent plus effective action to sever that joint tenancy. And so the survivorship feature disappeared before he died, and now the property becomes a tenancy in common between that what should have been a surviving joint tenant and the new buyers. So he's got a 50-50 interest instead of a 100% interest with people that he didn't even know about.
Roger, this feels like a problem, and is that a case as we look forward for agriculture?
I think your statement that it feels like a problem is an understatement. The most significant aspect of this case is not the outcome itself, it's the court's methodology. Historically, joint tenancy law has depended on objective acts affecting title. So traditional doctrine required destruction of one of what we call the four unities of time, title, interest, or possession before you could ever sever survivorship rights of a joint tenancy. And the Kansas courts in years past have relaxed strict adherence to those formalities. But even those cases, which the appellate court cited, in my view, incorrectly, but even those cases retain some connection between severance and legally operative conduct that affects ownership rights. And that connection appears weaker in this case than those other cases, because here the one joint tenant that did all of this and then died never completed a conveyance. And the court is treating an executory or an incomplete and potentially unenforceable contract as sufficient to destroy survivorship rights. And that's a huge leap. That's a substantial doctrinal shift.
Is this something that you think will continue to shift, or will we, per se, shift back?
Well, that really gets to what the implications of the decision might be, and whether it could go on appeal. So the Supreme Court in Kansas could overturn the appellate court decision if it is appealed. Now, sometimes people don't want to pay the additional cost for another appeal, so we'll see what happens here in this instance. But even if the Supreme Court doesn't, the Kansas legislature could amend the applicable statutory law to say you've got to have some type of physical act, such as a deed or a valid contract, to sever a joint tenancy. Because when you think this through, the implications of this are very significant in farm and ranch succession planning. Joint tenancy and survivorship deeds in that context are widely used in agriculture because, as I said earlier, they are inexpensive. They provide a predictable mechanism for transferring property at death without probate complications. And farm families depend on that predictability. Lenders and title insurance companies and estate planners, what we need is clear ownership structures when we're evaluating financing and collateral and transition planning. So this is a big deal. And so the other aspect of this, Shelby, is that ag operations often involve informal arrangements. We do a lot of things informally in ag. Possession changes hands without documentation. Family members are going to rely on oral understandings. Operational control shifts gradually over time. And when you factor that in to the court's reasoning here, those ordinary rural practices may now become pretty fertile ground for litigation over whether a deceased owner's conduct or statements implicitly severed survivorship rights long before death. And it's that uncertainty that creates risk, in my view, not only for families, but also for title examiners and creditors and future buyers. So it's a problem. And in this case, frankly, needs to be overturned, or the legislature needs to address it, or else we're going to have continued litigation on this issue in Kansas, which we shouldn't have.
Is there anything that people who are maybe in a joint tenancy can be doing to hopefully avoid this being a problem?
Yeah, make sure you know what your other co-tenants are doing. You got to be vigilant with respect to their conduct and whether they're thinking about severing a joint tenancy by their words or by their action. And frankly, I don't know how you monitor that in some of these situations. If you want to push this further to the ag lease situation, does this mean that one joint tenant owning farmland that's leased to one joint tenants in a joint tenancy as owners could lease the farmland to a farm tenant, and then one of the joint tenants could unilaterally terminate the tenancy? According to this, perhaps that's the case, and that would really create a mess. So I think it's an unfortunate decision. I think the court got haywire here. And it really's got some nasty tentacles if it doesn't get corrected.
Is this a case then where putting things in writing and having them legalized per se is really important?
Yeah, that's one way to address this. And again, this goes to what can I do to make sure that I don't have a joint tenant that I own property with that's going to do something that I disagree with. So what can we do? We just kind of have to think around corners and outside the box on this. What can I do to make sure that somebody I own property with in joint tenants isn't going to strip me of my survivorship rights? And that might be one way to address it. Can we do it by contract? Can we do it by some type of informal agreement? I don't know. This case raises a lot of those questions, but you definitely, and while this case is still sitting there, you definitely have to be on the lookout and be vigilant for what your co-owners are doing.
Roger, if people want to read more on this, how can they do that?
Well, they can go to my blog, and you can find that through my website, which is washburnlaw.edu/WALTR, or it's also on the AgManager website, which is the website for the Department of Ag Econ at K-State.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby.
That was K-State and Washburn law professor Roger McEowen. I will link his blog article, Joint Tenancy in Jeopardy, Did the Kansas Court of Appeals Go Too Far in Clark versus McKee, in today's show notes on agtoday.net. If you'd like to find it for yourself, you can also go to AgManager.info, select on Roger as a contributor, and it will be there. Once again, you can either go to agtoday.net or agmanager.info. We're cutting to a short break now on Agriculture Today, but stick around because we have more for you up ahead. You're tuned in to Agriculture Today, and we continue our show discussing pre-plant herbicide options for grain sorghum with K-State weed scientist Jeremie Kouame. Jeremie, thanks for joining us today.
Thank you, Shelby, for the opportunity.
Jeremie, why is pre-plant herbicides something really important for not only grain sorghum, but most of our crops?
When we talk about planting, we want always to start in clean fields. And so starting in a clean field gives our crops, a competitive advantage for them to outcompete the weeds, right? So being able to start with a herbicide program that has even like a strong residual program upfront allows, a very good start. So that's why pre-plant herbicides are really, really important to start very clean, again, to provide some competitive, help our crops be more competitive with the weeds.
Using pre-plant herbicides, does that help give grain sorghum enough time to get established and hopefully be able to, per se, create a canopy and be more competitive than against those weeds?
That's correct. Because again, once the crop reaches canopy, we'll receive less light on the soil surface. So we'll have a reduced amount of weeds coming up, so which is really good. And again, if we don't start with clean fields, what happens is the weeds become more competitive with the crop for those limited resources, right? We need a lot of rain, and if the weeds are not controlled before we start the crop, those weeds will be very, very competitive for water, for nutrients, and even for light. On top of that, though, the probability of, having weed control failures is higher when the crop is established in a field that already has weeds. So again, those pre-plant herbicides are really critical for a very good start for the crop.
And as we've discussed, we will touch on those herbicides, chemical control options, but is there ever a mechanical control option?
That's a great point. So again, because we are having a lot of herbicide resistance issues, we typically recommend that growers don't only rely on herbicides, because again, we want to preserve those herbicides which are effective. And to do so, we want to incorporate multiple other strategies, including mechanical, whenever possible, right? Also like cultural practices that include cover crops, for example, or row spacing, seeding rates, whenever the conditions are suitable for those practices. They all can help make the crop more competitive with the weeds, because again, it's all about outcompeting those weeds, right? So any strategies, planting date, seeding rates, row spacing, cover crops, everything that can help us make the crops more competitive are all good strategies to incorporate into our integrated weed management approach.
Thinking about chemical and herbicide control, what options do they have within that?
Compared to other crops, we have limited options for pre-plant control, right? And atrazine is a key herbicide when we talk about weed control in grain sorghum. It can be applied early pre-plant, pre-plant incorporated, pre, and even post. It does have some grass activity, but it's most of the time considered as a broad-leaved herbicide. And again, when the populations are still susceptible, it's going to provide a good control, even though we have atrazine resistance, which is widespread, but still it's a key herbicide for weed control in grain sorghum. Another option is going to be, of course, dicamba, which is a group 4 herbicide. So it's going to, again, help control those populations which are susceptible, pigweeds, wild buckwheat, lamb squatters. And sometimes we recommend the mixture of dicamba with atrazine, which allows earlier in the spring, for example, allows a good control of kochia. And dicamba applied at 8 fluid ounces per acre at least 15 days before planting grain sorghum can be a good option.
Is glyphosate or mesotrione also potentially an option for producers?
Oh, sure. Glyphosate is another option, even though glyphosate resistance is widespread in the state, but it provides a broader spectrum control of weeds. So it's an option. And most of the times we mix it with dicamba to even have a broader spectrum of control, but definitely it's an option. Mesotrione also is an option. It can be applied 21 days before planting up to pre-emergence. It is oftentimes mixed with group 15 herbicides like Dual, Magnum, or even Outlook. And mesotrione is one of the components, for example, for common herbicide pre-mixes like Lumax Easy or Lexa Easy, for example, which are very good pre-emergence or residual herbicides for grain sorghum. And it's going to provide some control of pigweeds, lamb squatters, kochia, as well as velvet leaf. On top of this, we also have other options, herbicide options like Perquat. I know my colleague, Dr. Lancaster, covered this a lot about the availability in 2027. So for Perquat, though, only certified applicators can handle and apply this herbicide. It's a non-selective herbicide, non-residual contact herbicide, and it should be applied in clean water or clean fertilizer to be effective. And so it's often applied with atrazine to enhance activity. And so again, in 2027, it won't be available. And other options as well will include Sharpen or sulfofenacil, which is a group 14 herbicide. That is going to provide some broadleaf weed control as well. So it can be surface applied, pre-plant, or incorporated. It will provide an excellent burn down control. It can be tank mixed with Clarity, atrazine, glyphosate, even to broaden the spectrum of control. Other options, we still have another group 14 herbicide, which is called Reviton. This herbicide received like a 24C special local named label. And if it's applied at 1 fluid ounces per acre, grain sorghum should be planted at least 3 days after application. But if we go with a higher rate of 2 fluid ounces per acre, the planting should occur about at least 7 days after application. And of course, group 15 herbicides, important because they provide some residual control. In grain sorghum, the ones which are labeled would be S-metolachlor, we know dual magnum and other herbicides. We also have the encapsulated acetochlor warrant, and Outlook can also be applied. And something important to keep in mind when applying those group 15 herbicides in mixtures, it's like the seed needs to be treated, it needs to be siphoned. So, because a siphoner is gonna allow the crop to degrade those herbicides, so we will not have some injury to the crop. But other products like Zidua are not labeled for weed control in grain sorghum.
Jeremie, you mentioned a couple of times that we're maybe seeing some continued resistance to these herbicides for weeds. So do you have any tips or reminders for growers as they might be applying herbicides to hopefully reduce the chances of creating more resistance?
Yes, that's a great question, Shelby. When we start talking about resistance, we recommend growers to diversify their approach, right? So again, from a chemical control standpoint, we always recommend to use herbicides which target multiple site of actions, because by doing so, not only we achieve a better control, but we at the same time are avoiding that the weeds become resistant to a single herbicide mode of action, right? So using products that target multiple site of actions is one strategy, and integrating other strategies which are not even chemical strategies are really important, right? So earlier we talked about how we could use cover crops, seeding rates, or row spacing, all these things. Even one strategy which has been explored in the past years was, for example, the seed destructor, which is a strategy because again, at harvest, the weeds, some of them have a lot of seeds still on the plant. And so the ability to target those seeds and to render those seeds non-viable when they return to the soil is a really, really important strategy to, for a long-term management of those weeds. So again, combining other methods is really critical to prevent herbicide resistance evolution.
Jeremie, I appreciate you taking the time to join us today.
Thank you very much for the opportunity.
That was K-State weed scientist Jeremie Kouame. I will link an Agronomy e-update article and the 2026 Chemical Weed Control Guide in today's show notes on agtoday.net. We're cutting to a short break now, but we'll be right back. You're tuned in to Agriculture Today, and we conclude our Wednesday show with part of the Beef Cattle Institute's Cattle Chat podcast. And today, Brad White, Bob Larson, and Phillip Lancaster answer a listener question.
It is a complex question about, best mature cow size. And, one of the things I think we need to point out right away is geography matters. Forage capacity, grazing capacity, those kinds of things, they dictate a lot about what kind of a cow fits in different environments. This is a conversation I'm going to have with Phillip. It seems to me that on a bigger cow is going to require more calories in a year. So in her 365 days, bigger cow is going to require more calories. Therefore, she's either going to graze more acres or I'm going to have to deliver more calories to her in the winter or while she's on forage or something like that. So she's got a higher cost. So a big cow has a higher cost. Now, if I get enough bigger calf from her that the income is coming in, that might be a good trade. But I need to know how much my cows are. What's the cost difference between a 1,600-pound cow and an 1,100-pound cow, and what's the value difference in their calves? And if I understood those types of things, I'd have somewhat of an idea for my operation what kind of a cow size would work best for me.
He talks about having 100 1,500-pound cows and 100 1,100-pound cows. And so if you're running the same number of cows with that big of a difference in their mature weight, then I'm either got to shorten up my grazing season because the 1,500-pound cows are going to consume more forage per day and my land is still producing the same amount of forage, or I'm overgrazing. And I think a lot of guys with it over the last 30 years, our cow size has increased, and I'm not sure we've adjusted stocking rate, which can be negatively hurting our productivity of our land. But if that's the case, then we're probably having to bring more feed to that 1,500-pound cow than the 1,100-pound cow. And then back to your question of overcoming that extra cost, there's some research out of Oklahoma State. If I remember the numbers right, you gain on average, about 6 pounds of weaning weight for every 100-pound increase in mature cow size. So about a 400-pound increase in mature cow size here, we'd gain another 24 pounds in weaning weight. So is that enough to offset the additional cost of maintaining that 1,500-pound cow? And so that all depends on your forage base and your feed costs and your calf market.
And I was going to say, and the price of cattle. I mean, so this year you could do some things differently than you could 10 years ago. The other point that he brought up, and this is one that we've not really addressed, is he said, my labor cost is not that much different. So if I have bigger cows, my labor cost is not that much more. So granted, you may have to put a little more feed out. You may have to, but not that much more between those two. What do you guys think about labor, and how does that work into your models?
And I'm not exactly sure how he means that his labor is the same, because I would think if my grazing season is shortened up with 1,500-pound cows, then I've got more hay feeding days. So that means I've got more days where I'm hauling feed to cows, which in my mind would increase your labor cost for those 1,500-pound cows.
Yeah, I agree. I mean, once you get to a certain number of cows, there's a pretty low slope as far as increased labor. You know, I can have a bunch more cows, and it's really about the same amount of time. But what really is how many grazing days do I have versus how many days do I have where I'm delivering feed. And I think it's not so much the number of cows that I have, it's the number of days that they're not grazing.
Which the counterpoint would be if you have the grazing land to support 1,500-pound cows, you might also be able to support, I didn't do the math exactly, but you might be able to support 125 1,100-pound cows.
And that probably wouldn't really increase your
And it probably doesn't change your labor much, right? Yeah. So if you have 100 cows versus 120 cows, how much does your labor increase? I don't think it's a 20% increase in labor.
Right, I agree
I think it's something much smaller than that, because you've already got most of your sunk costs. I'm going to feed them, doing stuff, and if I put out an extra bale or two, it doesn't take much.
Once again, that was part of the Beef Cattle Institute's Cattle Chat podcast. That's all we have for you today on Agriculture Today, but we'll be back with more for you tomorrow.